This is a science building, chemistry, physics. Am I on the screen? Okay, so Tom needs to stand right here. Will you, I'm putting the two of you in charge to remind Tom he's got to stand right here. And he's got about that far to go. Yeah. So. So your range of motion is about right here.
You mean I can't wonder?
No, sir.
But I like to wonder.
You can wonder at 10:45 this morning.
Okay, you can go that far, and then you go over there, we'll see how far you go.
Yeah.
Here to here.
Let's see.
You got about 3 minutes.
Anything. We go front.
All right. So you're live. If when you're doing the elections, you'll come around to the front of the camera, I will put my head back in. So.
You wait, one or two.
Come on in. It's not 42. Or sit here and play with I did come to this way. That didn't take that was not
Such a institution. I always thought they always talked.
Okay. I know it's so, it's just not like you Wow, great. So you got That's Peter. I was born. She was 27. I was 27. It's too much trouble.
Finish up the
Well, to all of you who found your way to this place today, welcome and congratulations. It's my honor to introduce Tom to you all, and I'm sure that you have known him. He's a member of this church, and he's been with us in the covenant class before. So Tom Ross is going to talk to us today about the justice system and his point of view about some things that are going on. But just to give you an idea, Tom graduated from Davidson. He went on to Chapel Hill. Are you happy
To
about
law
last
school.
night?
It's worth staying up for.
And he, I believe this is right, was the youngest judge of civil court in the state of
Civil
North
and criminal,
Carolina.
but Superior Court, yeah.
Superior Court, excuse me.
Yeah.
He's best known around here for being president of Davidson and then going on and being president of the University of North Carolina. So there's lots more we could say, but I think that's enough, except I do want to mention that Susan's here and another of the family is not here, and that is Bailey, who is this absolutely beautiful white dog that we've all gotten to know at the Pines and love. And
And
anyway.
who turned 1 year old today. Thank you, Missy. Well, I'm glad to be with you, and I want to give you permission to take a nap because it's an hour earlier than normal, so feel free. Don't worry about that. What I do want to talk about a little bit is how I view the courts becoming more political, the politicization of the courts, both in this state and other states and around the country. And I want to begin with some basics that you all know, but I think it's important that we get on the same page for purposes of discussion. And I do hope it'll be a discussion. So if you have questions as we're going through, just let me know and we can go off in whichever direction you would like, because there's plenty to talk about, much more so than I'll have time to. But let me begin with some basics. So our Constitution created, and the founders, I think, intended that we have three separate branches of government. The purpose of creating three branches, one of the purposes, there are multiple purposes, but one of them certainly was to create a system of checks and balances where each branch could be a check on the other. Legislative branch was given the power of the purse, so they could control expenditures in the other two branches. They had the ability to tax people to raise money. The other branches don't have that. And of course, given the power to develop and pass laws. The executive branch was created to implement and carry out the laws and to enforce them. And so law enforcement, those kinds of responsibilities and functions in government are executive functions. And then the judicial branch was created to interpret the laws and really to hold the other two branches accountable within the parameters of the Constitution and within the parameters of the law. And I think the founders clearly believed that the survival of our republic depended upon a judiciary that was functioning independently and that was functioning in a as much as possible in a way that is free from partisan consideration. And I think the reason that's important is public confidence in the rule of law. Because if you think about a republic, it is, ours at least, is based upon its underpinning is in the law. It's in the Constitution, it's in laws that are passed. And so that underpinning of the rule of law really depends on voluntary compliance for the most part. You know, a simple way to explain that, I think, is it's against the law to run a red light. There are lots of times, and you've been in them, when you're at a red light, there's nobody around, it's late at night, you want to get home, and you think, well, I'm just going to go. But 98% of us don't. We comply. Same with jaywalking. You know, it's technically against the law, or spitting on the sidewalk, or all sorts of other things that, you know, we try to control societal behavior, but most societal behavior is controlled by voluntarily. And if you lose the rule of law or confidence in the rule of law, then that compliance begins to erode, which erodes eventually a democracy. And I think the founders believed, and I certainly do, that the republic and the underlying democratic principles that support the republic will vanish if we lose the rule of law. So to me, and I'm a lawyer, so I admit my bias, the court system and the enforcement of the law through the courts is the foundation of democracy, and it's what allows it to be preserved. So with that background, I tell you about this only because I think it's reflective of the times, in the sense that we've been through some of this before and survived. And I certainly felt strongly we would survive when I gave this speech I'm about to tell you about. I'm not so sure I feel quite as strongly that we'll survive today. But in 2000, I was privileged to give a speech in the Great Hall of the Supreme Court. There were mostly chief justices from the states there, but there were also members of the U.S. Supreme Court and other people. And it was November 13th of 2000. And those who are old enough in the room to remember, November 13th of 2000 was 6 days after the election of 2000. And there was no declared winner. And so I stood up that night to give a speech. And the theme of my speech really was about losing public confidence in the courts because of our failure to address issues of race and issues of economic status and so forth in the criminal system. And that there's lots of evidence that, you know, there's a disparity of treatment between people of color and people without economic means and the rest of us. And so I was talking to these justices about why I think it was important to address those issues if we were going to preserve public confidence. That was the theme of the speech. But I started out by saying this: as we sit here tonight, our democracy is under stress. 6 full days after Election Day, we still do not know who our next president will be. It's very likely that the outcome may be decided only after action by our courts. Now, I'll just stop for a minute and say, and Susan, I think, can verify this, we were sitting at the table with Chief Justice Rehnquist, who immediately turned white, because I don't think he had thought that they were ever going to have to get involved. But and then I went on to say, this is not something we want, but should we be surprised or angry if it happens? And the answer, in my view, I said, is a resounding no. Instead, we should be thankful that our system of government and the rule of law allow us to resolve disputes, even about something as important as who will hold the most powerful office in the world. And that can be decided in the courtroom and not in the streets. We should be proud that our citizens still have enough confidence in our courts and judges to trust that we can resolve such important disputes fairly and in a just manner. And I think there were a lot of people at that point when the lawsuits were filed, and there had not been any at that point, when the lawsuits were filed and all that happened and Bush versus Gore happened and the Supreme Court ruled. I think if you look back, the public accepted it pretty much without question. Some people liked it, some people didn't. You know, they were upset. But mostly they blamed the Florida court and what was happening there, or what, not the Florida courts, but the Florida system, election system. But no one really questioned the power of the Supreme Court or the authority of the Supreme Court to decide the outcome of the case. So I really was at that point, I think, confident that we would survive that. We're in a situation now where, and I'm not just referring to this year's election, but to where I think the courts are becoming so political that I'm not sure we will survive it. And so I want to talk a little bit about why I don't feel as strongly or as confident as I did 25 years ago. Let me also give just a little more background. Each state and the federal government, federal courts, have a code of judicial conduct. You can look North Carolina's up online if you want. And I'm going to be sharing a few parts of it as we go through, because I think it's important to see what's happening and compare that with the code of conduct. So the preamble, just to give you the structure of the system, the preamble reads, an independent and honorable judiciary is indispensable to justice in our society, and to this end and in furtherance thereof, the Code of Judicial Conduct is hereby established. And then from Canon 3A, a judge should not be swayed by partisan interest, public clamor, or fear of criticism. And having served as a judge for 17 years, there are plenty of times when you're criticized publicly, when you are under pressure to do something, rule a particular way in a particular case, and it is expected of you, or at least it used to be, that you would put that aside and decide a case based on the law. I remember one case in Greensboro that always sticks out to me is it was a rezoning case of all things, but it was very hotly contested. It was out around the watershed area, and it was a fight between developers and environmentalists to try to protect the watershed. Was their goal. And I got approached at parties or wherever we went. We'd go out to dinner, people would come up and talk to me about it, want to get me to do something. And I just tell them I can't talk about it. I'm not going to talk about it. Fortunately, ultimately, I got the parties together and sat down, and we got it resolved in an effective way, I think. But it is not unusual for judges to get that kind of pressure. And the key is you got to resist it. And it's increasingly difficult in today's world, I think, for some to resist the influence of partisan politics, because for many of them, that's how they get there, and they're afraid to say no to those who helped them. And look, you're never going to remove all the politics from the judiciary. There are always going to be some, because it is part of judicial selection, if nothing else, right? Even at the federal level. At the federal level, we designed our system to have the president nominate people, have them confirmed by the Senate, and then serve lifetime terms. And the reason lifetime terms were put in is to ensure, to the extent possible, independence. So that once you got on the court, you would be independent from all that political pressure and other kinds of pressure, right? In state courts, judges tend to have longer terms than most elected officials. And they're appointed or selected or elected in lots of different ways. There's a great variety of different ways, but all of them, frankly, involve politics, right? I mean, I first went on the bench, I was appointed by the governor, and then I had to run for election 3 times. And 2 of those elections were in statewide elections. One of them was in a district election because things kept changing. But the goal is, however you get there, is then to set that aside and not be political, but instead to base all your decisions on the rule of laws. And we can talk about judicial selection another day, because it is a fascinating topic in and of itself, to try to find the best way to do it. I'm not sure there is a best way, but there are ways that are a heck of a lot better than we have. When I was working at Z. Smith Reynolds Foundation, we spent a lot of time and money investing in organizations to lobby for and get passed legislation that would require nonpartisan judicial elections and publicly funded judicial elections. Again, to try to take partisan politics out of that. We got it all passed so that, for a while in North Carolina, appellate judges were elected on a nonpartisan basis, as were Superior Court judges, and appellate judges were publicly funded. But that all got repealed in 2011. And now we're back to partisan elections, of course. Let me, I said this is all key to the public confidence in the courts. And I don't know if any of you look at polls about how the public feels about various institutions. They're out there, easy to find, just Google them, and you'll see that generally legislative branches are at the bottom. And for many years, the judiciary and judges were at the top of public institutions, at least. And really at the top of a lot of different institutions, because people had general respect for them. But here's what's going on. And these are just some recent polls. In 2022, the Institute for the Advancement of the American Legal System polled attorneys. Now, this is lawyers who practice in the court system. And 35% indicated they had less confidence in the courts because of politics. In 2022, there was a Gallup poll that found that only 25% of Americans had a lot or a great deal of confidence in the U.S. Supreme Court. And this was down from 36% the year before, 36 to 25. Now, you might remember what happened in 2022 that could have changed that. The National Center for State Courts found in 2022 that Americans indicating that they had some or a lot of confidence in state courts is at 60%, and that's down from 64% the year before. So, and that's been declining. It used to be in the 80% range. So what you're seeing is a steady decline, however you ask the question, of American confidence in the courts. What I'd like to do is talk a little bit about why this is happening and some examples from North Carolina and from other states and from the federal government. And then we can open it up for discussion, which I think we'll have plenty of time for. So why is it happening? Well, some people want to point back to Bush versus Gore and say that was a political decision, and clearly an example of how the Supreme Court's political. It has a role for sure. It's not the reason, the primary reason for certain. Much more important, I think, is the selection and confirmation process of members of the Supreme Court, which has become much more political than it used to be. And it goes back to wanting to be Justice Bork and his confirmation hearing, which people are blamed as being a very political outcome. Clarence Thomas's hearing was seen as political by some. And then as we move forward, any justice, doesn't matter who it is perceived as political, and they're attacked for all sorts of different reasons. And, that may be fine inside the Senate, but the perception that it creates outside the Senate is that every one of these people are political tools. And when they get on the court, they're going to act like political tools. And if you go back and look at the history of the Supreme Court, that has not been the case. You have had people that have been appointed by a Republican president or a Democratic president who people think are going to act one way or the other, and they just don't. They vote their conscience because in part they have that lifetime appointment and they learn how to be independent and to think for themselves and not to be governed by partisan politics. I'm not sure some of our current justices have learned that yet. And some of them have been on the court a long, long time, and they seem to be slow learners, but we'll see. But I think it's also fair to acknowledge that there are other things that affect the confidence in the courts besides politics, right? I mentioned a couple earlier, race and money. There's always been a perception by everybody, white, black, Asian, Hispanic, whoever you are, that people with money have an advantage in the court system, right? They can afford a lawyer. They can, in the eyes of many people, buy their way out of problems, that sort of thing. And it is a perception that has reality to it as well. Same is true of race. There are people who people of color who believe they are disadvantaged because there's advantages in the courtroom to being white. Again, I think that perception has reality to it. You can look at the numbers and you will see it, particularly in the criminal courts. This is what I was talking about when I spoke back in 2000, because I'd been doing a lot of work around criminal sentencing reform at that point to try to take as much as possible bias out of sentencing, which is hard to do because it's human beings. But if you have some guardrails around it, it certainly helps, I think. So you have to realize there are other things besides politics. But I think there has been a movement in this country over the last 25 or 30 years by several groups to make the courts, intentionally make the courts more partisan and to have more control over them. And one of those groups is the Federalist Society. And there are people who believe that the Koch Foundation and others that partner with them heavily funds the Federalist Society. The Federalist Society has become essentially a group that has veto power over appointment of members of the Supreme Court if a Republican is in the White House, and in fact, often choose who they want, and that's who gets nominated. And I started to call them cynics, but I'm not sure they are. There are people who believe that the Koch Foundation has its own motivations for this. And it's not so much because they want one party or the other to be in control of the court, but they want certain kinds of outcomes. And one of the most controversial things that's happened that you've probably read about in the last year or two is, Clarence Thomas has for years gone to the Koch Foundation's annual policy conference and been a speaker, which he's been criticized for as violating the federal code of judicial ethics, which doesn't apply to the Supreme Court, as we know now. But he's been going to that for a long time. And the thrust of that has all been, not all, but much of it has been in that conference of conservatives is focused on a doctrine called the Chevron doctrine. And which is, for most people, they don't know what it is and don't care, but you should care, because the Chevron doctrine is a doctrine of administrative law as much as anything else. It allows the federal executive branch agencies to make rules. So Congress will pass a law, and if you've ever read anything passed by Congress, it's lengthy, full of a lot of words, but not full of a lot of direction and not full of a lot of detail about how to implement something. That's left to the agencies to develop rules. And there are all sorts of guardrails around the agencies. They have to publish their rules. They have to give public comment. That goes on for a long time. There are a lot of people critical of the way that's done, but that's the way it's done. And this underlying effort, is to get rid of the Chevron doctrine. And so that agencies can't make rules basically to implement laws, which, given the state of Congress today, would basically stop government in many ways. There just wouldn't be much that could be done. Because without those regulations in the agencies, you can't implement the laws that are passed because they're too vague and nebulous. And Congress would have to do all that kind of detail work themselves. And you can imagine, since it's functioning so well now, how that would go down. Probably not too well. So that's the Federalist Society. But at the same time, there are groups in particular states, parties or others, people who fund those parties, who specifically have tried to take over, in their minds, take control of state Supreme Courts. And this has actually been a national, do you all know the group ALEC? You ever heard of ALEC? So ALEC is the American Legislative something group.
Exchange Council. Exchange Council.
Exchange Council, exactly. And it, started as a place where legislators would go and they would talk about issues, and ALEC would sometimes propose ideas of ways to solve them. Over time, it has become essentially the developer of policies that are then sent out primarily to the Republicans that are then, brought up in every state. So a lot of, for example, the transgender legislation, anti-transgender legislation came out of ALEC. Well, the idea was to do the same with the courts, to build an effort to control the state courts, so that when these laws that might, get passed and then attacked could be upheld because the courts would do that. So, and we've seen, I think, more states become much more political in their elections as a result. So in North Carolina, when I was on the bench, which again is 25 years ago, so a lot's changed in that time, but there was, if there was a challenge to a member of the Supreme Court, doesn't matter which party, the amount of money spent in the election was tiny. Because most judges at that point didn't want to take money from lawyers because they'd then be appearing before them, and nobody else cared who the judges were. They really didn't. Now, in state judicial elections, there are millions upon millions of dollars spent. And it's mostly by outside groups. And both parties who are now in the fight to try to control the judicial branches. And as that has occurred, both at the federal level with the Federalist Society and with the states becoming more political and people trying to control the courts, it is, in my mind, elevated substantially the perception of politicization of the courts. And I think I have some examples where I would argue it has increased the reality of politicization of the courts. So let me talk about some examples. In 2022, let me create the context. In Wisconsin, the legislature was controlled by the Republicans. There was a Democratic governor. The Supreme Court was at that point a majority Republican. In 2022, there was an open seat. A woman ran for that seat as a Democrat. She was elected, and literally immediately after she took the oath, an effort began to impeach her. And they also began a movement to force her to recuse herself from a redistricting case and use that, which she wouldn't do. And they used that as a basis to try to impeach her. Didn't happen. And she's still on the court. But that, is the kind of political, and the reason simple, it was about gerrymandering and redistricting, because whoever they thought, everybody probably thought this in both parties, whoever controlled the court was going to get the maps right? Shouldn't be that way, right? I mean, the maps ought to be drawn fairly to begin with, and then the courts ought to stay out of it. But that's not been the case. We had a similar situation in North Carolina, where there was an effort in, get the timing right, 2022, to recuse. Well, let me back up on that one too and give you the context of that. So there were maps passed after 2020, as is always the case. They were challenged. The maps were held unconstitutional. The legislature redrew the map. There was another lawsuit, this one called Harper versus Moore, and it was on track to go to the Supreme Court. The maps had been upheld. Well, the maps were under attack. A 3-judge panel was appointed. The 3-judge panel appointed 3 special masters. One of those special masters was a former Republican member of the Supreme Court who was still a Republican. Another one was a former member of the Supreme Court who ran as a Republican when he was in office, but had changed to an independent. And the third one was me. And we were asked to look at the maps and determine, based upon certain criteria in the previous Supreme Court opinion, whether or not they were constitutional. And we upheld the House maps and the Senate maps because, as badly gerrymandered as they were, they didn't meet the test of being unconstitutional under the test as the Supreme Court had handed it down, our North Carolina Supreme Court. But we did find that the congressional maps were unconstitutional. And so we gave our opinion to the trial judges. They agreed with us. And that 3-judge panel, by the way, was 2 Republicans and 1 Democrat. They agreed with us and asked us to redraw maps. We redrew maps. That went to the Supreme Court, who upheld our maps. Our maps were used in the 20, I guess I got the timing wrong, because they were used in the 22 election. All that would have happened in 21. And in the 22 election, our maps were used. No, that's right. It was January of 22. And then the election was in that fall. And that fall, in the election, using the maps that we drew, there were 7 Democrats elected and 7 Republicans. In a state that has historically voted about half and half for Congress. If you total the votes up, right? If you take all the votes cast for Congress in North Carolina, every year almost, it's 50, 50, 49, 51, right in that range. So that was a pretty close outcome. What happened then is after those maps were used, and I should also back up and say in 2021, the North Carolina Supreme Court that was controlled at that point by Democrats, had ruled that gerrymandering, if it was partisan gerrymandering under certain criteria, was unconstitutional in North Carolina based on the state constitution. And when that happened, and the Supreme Court ruled, the appellate rules allow 15 days for the losing party to seek a rehearing. The legislature, which was the party involved, the losing party, did not seek a rehearing. But instead said publicly that fall that they were going to seek a rehearing after they took control of the Supreme Court. So in the 2022 election, they did in fact win several seats and became a majority of the North Carolina Supreme Court. And within weeks after winning those seats, they filed for rehearing on the redistricting case. So clearly in violation of appellate rules, which they basically ignored and allowed it to happen. They took the case, they heard it, they reversed the previous Supreme Court opinion, just tossing out the precedent that existed. Those maps are being used in this election. They redrew the maps. They're being used in this election. Everybody predicts at a minimum it'll be 10-4 Republican split in the congressional district. There's a chance it'll be 11-3, just because of the way they gerrymandered it. So, but there's an example, I think, where the North Carolina Supreme Court reacted to partisan activity because they'd just gotten elected with the support of their party, and they were, and there was an effort in there early on before the Democrats decided the case to get Anita Earls, a Democratic justice, to recuse herself because she had been involved in redistricting cases previously. After the Republicans took control of the court, there was an effort to ask Phil Berger Jr. to recuse himself because his father's president pro tem of the legislature, and the legislature had drawn the maps. And there is a provision in the judicial code which says you're not supposed to sit on cases involving your family, which the Democrats argued. And of course, the Republicans' response was, well, he's not acting as a family member here. He's in a public office, right? So, and recusals left up to the judge. And of course, Berger didn't recuse himself. Neither did Anita Earls. But this is an example, I think, where despite precedent and despite appellate rules, partisanship won out at the Supreme Court. And we're in the middle of another one of these where about 30 years ago, a case was filed by Hope County and one other county under the North Carolina Constitution, claiming that their public schools had not been adequately and fairly funded, as is required by our Constitution. That case has been going on for 30 years. For a long time, it was in the hands of a Republican judge, Howdy Manning, and he ultimately ruled that the state had an obligation to fund these schools and ordered the state to fund them. That got appealed. The North Carolina Supreme Court, back at that point, the Chief Justice was Burley Mitchell, who was a Democrat, but a very conservative one. And the court was pretty conservative at that point. But they upheld the trial judge and said, yes, the state has an obligation to fund public schools under the Constitution, and they're not meeting that obligation. It's been sent back to trial courts then, who have tried to figure out how much the state should have to pay. There was a group of pro-public school groups that developed a plan, about a $750 million plan of what the state needed to do to get to the level of adequate funding of the public schools. That was heard by a trial judge, and it was, appealed, I guess, and affirmed by the Supreme Court. And now, and the Supreme Court has basically ordered the legislature, this was when it was controlled by the Democrats, ordered the legislature to pay the money to fund the schools. And again, the legislature has said all along, we're not doing it, and you can't make us. And they have now filed for a rehearing after they won control of the court of the Leandro case. So this case now 30 years old. Every judge that's touched it, Democrat and Republican, have found the state has this duty and responsibility. It's now pending on rehearing before the North Carolina Supreme Court. It was just argued a couple of weeks ago. Again, violates appellate rules to rehear it at this point, but that's what they're doing. And most people believe they'll reverse the case. And again, in this case, Justice Burger Jr. was asked to recuse himself because of his relationship with his father and his father's public statements about how they weren't going to follow the court order. And this time he referred it to his colleagues for their opinion about whether he should recuse himself. And of course, it was a partisan split saying he shouldn't, and he didn't. And so that case will be coming down the pike here at some point before long. I might be wrong. They might not reverse it, but I kind of think they will. Here's a little bit more of a inside baseball thing, but it's kind of interesting to see how their things are so political that sometimes they turn on their own. Both parties do, but this is one example of. So and it shows, I think, also how some of the justices are disregarding the code of conduct. But so there's a provision of the code of conduct, Canon 3B, that says a judge should exercise the judge's power of appointment, because you do sometimes have the ability to appoint a clerk or some other person, only based on merit, avoiding nepotism and favoritism. So remember that one. There's also one that Canon 12C that describes what is prohibited political conduct. And one of the provisions, part 2 of that canon, says a judge or candidate should not endorse a candidate for public office except as permitted under subsection B of the canon. Subsection B allows you to endorse somebody else if you are a candidate, right? So Phil Burger Jr. was elected in 2020 to an 8-year term. There's a woman named Donna Stroud who was chief judge of the North Carolina Court of Appeals. She's a Republican, been on the court for a long time, and was chief judge. The tradition in North Carolina is the most senior judge, and the chief justice makes this appointment. The most senior judge on the Court of Appeals is appointed as the chief judge. So she was chief judge and had been for a long time. Burger had served on the Court of Appeals before his election in 2020 for 4 years. At some point in there, the Court of Appeals needed to appoint a new clerk. And there apparently were 2 candidates. One of those candidates, I don't know what party one of them was in, but he ended up being the favorite of the court and was appointed. The other one was Burger Jr.'s former law clerk. And he pushed really hard for her. And their emails, I'm not making this up, their emails that show him saying, he should be appointed because he's a Republican. The other guy is the choice of the Democrats, and they're trying to ram it through. So appoint my guy, and he was pushing hard. Well, the court, and he blamed Donna Stroud when the other person was named clerk. Even though there are 15 members of the Court of Appeals, they had a secret ballot vote. There are 10 Republicans and 5 Democrats, or they were at that time. And of those 15 judges, the majority voted to hire this person as clerk that Berger didn't want. But he still was not happy with Donna Stroud. So in the 2022 election, remember he has a term that expires in 2028, he publicly supported a woman named Beth. Let me see if I can find her name, only because it becomes important in a minute. Beth Freshwater Smith was her name. He supported her, as did Chief Justice Newby in the 2022 election. Now, Chief Justice Newby was a candidate at that point because he was running against Sherry Beasley for the Chief Justice job. But Berger wasn't a candidate. He'd been elected in 2020, wasn't going to be a candidate again to 2028. And he was accused by some of violating the canons by endorsing a candidate when you're not a candidate. His position was, well, once you're elected, you're always a candidate, which has never been the way the canons have been interpreted. And since then, Chief Justice Newby has indicated he wants to change the canon so that that's exactly what the canon will say, is that if you're a candidate, you're always a candidate. And so because he also has, I think, exhibited a desire to be fairly political, and I'll show you why in just a second. So they endorsed Stroud's opponent, Beth Freshwater Smith. Despite that, she won and came back on the Court of Appeals, came back as chief judge, and continued along just fine until late last year, early this year, I think late last year. Chief Justice Newby removed her and appointed somebody he likes as the chief judge, which I think stunned a lot of people that would happen, but it did. And, I think that's an example of sort of the kind of use of politics that shouldn't happen within the courts. One other example in North Carolina, and then I can talk some about what's happened federally, or I can take questions, whichever. There is a provision of the canon that allows judges to speak, write, lecture, teach, or participate in cultural or historical activities, or otherwise engage in activities concerning the economic, educational, legal, or governmental system, or the administration of justice. Justice Anita Earls interpreted that as allowing her to speak about diversity in the courts, believing that was important to the administration of justice. She did that at some public event, and shortly thereafter, a complaint was filed with the Judicial Standards Commission saying she had violated the canons. She felt she was within her rights and that it was her First Amendment right to say it, first of all, but secondly, that it didn't violate the canon. So she sued the Judicial Standards Commission, got a lot of national attention. Eventually, the Judicial Standards Commission dropped the case. But after that, the legislature changed how the members of the Judicial Standards Commission are selected. There'd always been 4 members of the Bar Association, figuring judges should be a part of the process. Lawyers should be a part of the process. Those were taken away, and now it's going to be judges that are selected by the legislature that will serve those 4 positions. The others were left as they were. The other disturbing trend to me in the state is the legislature this past year in their budget created 10 new Superior Court judges that would be selected by the legislature for 8-year terms, just like other judges that are publicly elected now. So I think there are lots of ways to think about that. some people would argue it violates the Constitution. I don't think it does, because the Constitution basically just says judges are to be elected. It doesn't say by who. But this could be, and I fear it might be, a movement toward changing our judicial selection system away from public elections to legislative elections, which happens in South Carolina and Virginia, and is immensely more political than I think even our current system, which is way too political, because then you're beholden to the members of the legislature. So that's something to watch and see if it comes forward. So let me stop and see if you something you want to talk about, or if not, I can talk some about the feds.
I'm a licensed attorney up in New Jersey, and we don't do it this way. There are no elected judges. And bar associations have a chance to make, well, it doesn't take politics out of it all the way, but the parties make nominations or suggestions. It goes in, the bar association has some comment, but then
The governor.
there's an appointment. And of course, it's not having to run for re-election too. So you're free from worrying about how am I going to offend somebody and I won't get re-elected. So I was interested in hearing the differences between here and New Jersey. I knew you were elected here, but it seems like a lot more problems than we.
Well, it has, again, I think there are ways to have elected judges that aren't as big a problem, and one of them is nonpartisan elections. Our nonpartisan election system, when we had it, worked quite well. Both Democrats and Republicans ran, got elected. But people complained, some partisan people complained that, well, we don't know who they are and we need to know more about them. And so a party label will help us. So they they repealed it and put partisan elections back, and, then the money began to flow, and it's become I think a much more dangerous system. So
when you have public elections, how many people in the citizens would know the particular abilities of a proposed candidate for judgeship?
Yeah. Well, clearly I got elected 3 times, so they must not have known anything. Or it wouldn't have, it wouldn't have ever happened. But no, I think that's one of the issues is that, how do you inform the public about who these people are and what their political views are and what their views on particular issues are shouldn't be discussed anyway, right? I mean, judges shouldn't be telling you, here's how I feel on this issue or that issue, because a case is going to come before them. And, that's showing bias up front, and will lead to people wanting to recuse them, rightly so. So that shouldn't happen anyway. What should be talked about is their ability to be fair, and their integrity and their background and, experience is a big thing,
Taking the election out takes the money out too, which is an important aspect.
Absolutely. Absolutely. Yes, sir.
Is there a state that does it right?
There are states that do it better. Like I say, I don't think there's a perfect system. I served in 1985, I guess, on a legislative commission in North Carolina that was bipartisan, and had legislators, but also judges and others. And I remember the Democrats were in control of the legislature, and we recommended moving away from elections to an appointed system that would have basically a merit selection board that would nominate certain candidates, kind of like New Jersey. It wouldn't be just the bar, it'd be a broader group, and nominate them to the governor, and the governor would have to select one of those 3 names. And if he didn't, it would go back to the process again, and other 3 names would be submitted. We recommended that. It was voted down by the Democrats, and Chief Justice, later to become Chief Justice Henry Fry, and I filed a dissenting opinion with a couple of Republicans saying this is a mistake. And I remember arguing to Liston Ramsey, who was Speaker at the time, that the tide will turn. If you think you're going to be able to keep partisan judges, it's not going to happen over time. The tide will turn, and you're going to regret this. And I don't know if he died before he regretted it or if he regretted it after he died, but one time or the other, he regretted it. So, but, it just shows you how even then, people didn't want to change something they thought they had control over. Judges weren't near as partisan back then as they are, but people wanted their own party in there, Missouri has historically done it pretty well. They have a merit selection system that seems to have worked relatively well. I'm not as up to date on all this as I used to be, but I later served on an ABA commission that looked at all 50 states, and they certainly were one that stood out as somewhat better. There are those that have nonpartisan. There are those like New Jersey that has appointed systems that work pretty well. The worst ones are partisan election ones. They're the worst, and they're mainly, and I mean, this is all Reconstruction stuff where we, in the South, we wanted to elect everybody after the Civil War, and that included judges and sheriffs and everybody else, which just isn't the case in a lot of the country. But there are other ways to do this better. So just like gerrymandering, it's never perfect, but there are better ways to do it than we do. So, yeah.
What do you think about, pardon me, states now trying to assume what has been traditionally federal legislation and federal law, such as immigration, and ignoring what the federal rules are?
Yeah, I mean, it reminds me of, history repeats itself. So let's go back to the Civil Rights Movement and, sending the National Guard to Mississippi. It's the same thing. Federal law is federal law. If the state doesn't comply with it, then, it's the executive branch, federal executive branch's responsibility to make them comply. They're part of the union. They agree to that. That's part of what the Constitution is about. If there's federal preemption in an area, states are not supposed to legislate, nor are they supposed to try to enforce something that is different from the federal law. So, I mean, that's just plain out simple law. So, if states start ignoring it, then we got problems. This is why confidence in the courts is so important, because, if in Texas is the example I think you're referring to about immigration, passes a law that's contrary to federal law, because immigration is a federal preempted issue, and refuses to stop enforcing their own law. If the President of the United States doesn't act on that and have somebody go down there and stop it, then that is simply a disregard for the rule of law. And it's one step in an erosion that will eventually lead to what happened in the Civil War, succession and, a war. So that's my view of it. It's not good. Other questions? But I'll talk about two more cases then. One of them is the most recent decided case by the Supreme Court that is some viewed as political, which is the 14th Amendment case about whether Trump should be on the ballot in Colorado. To me, the outcome of that case was very pleasing. And you think I'm nuts to say that, but it's very pleasing for this reason. First of all, I think the court was right about it. But more importantly, I think the justices handled it extremely well, in that you saw them, if you listen to any of the argument in that case, you saw them asking all the right questions. It wasn't about this particular circumstance. It was about what was meant by the 14th Amendment and how could the 14th Amendment be enforced? And if you tried to enforce it, what would the consequences be? Would you allow states to decide one thing and, to have it come a different way in a different state? And what would that mean in terms of people's acceptance of the winner and all that sort of thing? And I think the 14th Amendment was really designed not to stop somebody from running, but to stop somebody from serving. And so I think the court did the right thing. They said it doesn't really apply at this point for two reasons. One, it's not about running, it's about serving, but also it requires implementing legislation before this can be done. The flip side of that argument is, well, we let states decide all sorts of things on the ballot anyway. For example, in the area of redistricting, the federal courts have said, hey, that's not our business, that's up to the states. They control federal elections, which they do. There are plenty of times when, look right now, there are ballots that have Robert Kennedy Jr. on the ballot. There are other states where that hasn't happened because they have ballot rules about who can run. Same true with the Green Party and the Libertarian Party. They can get on some ballots and not other ballots. So states make those decisions already. So you could argue where they should make this one. But this was an interpretation of a constitutional amendment. And I think the court got it right. It was really good to see it be a unanimous decision. There were dissents here and there. Not dissents, but concurring opinions that explained the reasoning, and there was different reasoning. but it's a great outcome. Now, what I hope is that we're going to see the same thing in the second case that they've got, which is the immunity case, where President Trump has said he cannot, in the January 6th case, he has said, the Jack Smith case, that he cannot be prosecuted because he is absolutely immune from anything that happened while he was president. The lower court, the three-judge panel that handled this, I can't remember now, I think had 2 Democrats and a Republican on it, or maybe 2 Republicans, and I don't know who it was, but they were unanimous and very strong, incredibly well-written decision, 100 pages, saying why this cannot possibly be the law. Now, I wish the Supreme Court had just said, we're not going to hear the case, because that would have been, better in many ways. But they've taken it. They're going to argue it in April, and we're going to see what they say. It's critically important, not just for this election or for the trial or for any other reason. But if you say that the law in the United States is that the person serving as president is immune from anything they do, then it'll be just like one of the judges in the hearing asked, which is, do you mean to tell me that a president who doesn't like his political opponent could send the Navy SEALs out and have that person executed? Is that what you're telling me? And be immune from prosecution? Because the Trump lawyer's position was you could only be prosecuted if you had previously been impeached for those reasons. So, if you couldn't get an impeachment passed because of who's in control of the House and Senate, then basically murder's permitted. And I don't think that's what our rule of law would allow. So I cannot imagine the Supreme Court finding that he's absolutely immune or that there's any conditions upon which he can be tried for activities, that occurred during his administration or any other president for that matter. But we'll see. It's going to be interesting. It's a great opportunity for the Supreme Court to be 9-0 again. And I think that would do their image a tremendous amount of good if they were, because that would be one case where people perceive it as having ruled for Trump 9-0 and one where they ruled against him 9-0. And that's perception, and that matters to the public, I think. So, anything else? Okay. I'll give you. Oh, you got one. Okay.
What do you think you would recommend to try to bring some equilibrium back to the judicial selection process in North Carolina? I would recommend that we immediately go back to nonpartisan elections and publicly funded elections of appellate judges to take the money out of those races. People don't spend much money on. The only people that spend much money on Superior Court races, trial judge races like I was, are lawyers. And that's, you don't want that either. But, the big money is spent on appellate races, mainly the Supreme Court. So if you take the money out of it, I think that's a big step forward. But if you take the partisan label off, that also is big. In part because the public doesn't know who they are. So, they're not going to vote based on their partisan. They're going to try to find out something, or they'll vote on their name, for heaven's sakes. I don't know. I mean, there are people who argue Mark Martin, who was Chief Justice of our state for a while, got elected simply because his name was Mark Martin, same as the race car driver, which, who knows, might be true. But anyway, that's where I would start. I would love to see us move away from elections altogether. The ideal system in my mind is a system that has a group like the Judicial Standards Commission, if it were previously constituted, not the way it is now, but a basically nonpartisan, as best you can get it, Judicial Standards Commission that would review potential candidates, would assess their experience, their ability, their integrity, and so forth, and pass or fail them, and then send 3 candidates to the governor, have the governor appoint somebody, have that person serve an initial term of, let's say, 4 years, and then stand for a retention election, and then get for judicial retirement, it takes 24 years. So I would have that first term be 4 and then 2 successive 10-year terms where you have to stand for confirmation elections or be reconfirmed by the Senate, however you want to do it. I don't care. But the point is to keep the long terms as much as best you can, but to try to take the politics out of the selection. Because if you take it for most people who want to be a judge, the reason they want to do it is because they want to be in a situation where they can decide things based on the rule of law. They're lawyers. That's what they want to do. They see themselves as being able to do that well. And so the ideal is to find a system that reduces the politics in the selection process and then protects them from politics after that, and I think that's probably the best we could do is a system in North Carolina, which has been proposed and not passed so far. So the reason I go immediately to the other is because it doesn't require a constitutional amendment. So, okay, thank you.
Well, Tom, thank you so much. We'll have you back sometime.
Yeah, sure.
Wow.
Let's see, next time.
Next time is Susan Manning and a group who's going to be talking about their journey with the footprints of Paul. And we're back here for the rest of the summer. Good. Thanks for being here.
Is it every place?
Part of that,
Two more still living at home. So maybe they get out and go to college, they spread out all over. So then we can come down.
So we're there.
That's right.
The other thing I'll say is,
Then I would really black.
that was the name of the case. The Chevron oil case that where the channel.
Yeah, that's the easiest way.
And lost. And so getting Chevron.
He didn't exactly tell you what was on surgery, but he was planning to come. Thank you. So, so anyway, that's how I've been, and I'm just happy as a large. I'm happy that it all turned out so well.
If you can't be this kind of noise, I can't arrange anything.
When is that?
Really?
Yeah, it's supposed to be a cool place to go.
You're young. 45, 45. Yeah. You know, oh, because I really want you. It's true. It's just,
We spotted J-Rock for a few minutes.
that almost like way over my head already.
Yeah, Mr. Coffee.
That's okay.
But that was a nice one for us. Yeah. Well, upstate in South Carolina, near Clemson. Yeah.
Which town?
West Union, do you know Clemson?
Nephew lives in Anderson, yeah, so.
Well, Anderson's where we have to go to shop.
Yeah, I know, the big city, right?
Yes, for sure. But I love it. We've only been there 4 years.
I can't believe it. I like it.
We're like over 50.
We were there signifying times. So how
We
much
High school.
We were really
We're way
young.
over 60.
Y'all must have been like really young.
We're in our 20s, late 20s.
But you really were. That's where our kids are now. So
Good to
good to
see
see
you.
you.
Bye-bye. Good thing you're a judge.
And like yourself.
Well, that- But I didn't feel that. It has to do with analytics. I mean, what? People do that. I don't know.
Yeah, we're gonna get into the action, yeah, too, but-
Yeah, I think